The title to real estate represents the legal story of ownership. In earlier lessons, you learned how encumbrances and liens define the limits of ownership. Now we turn to the language of title itself, how the law recognizes ownership, how the public learns about it, and how ownership moves from one person to another. In this chapter, we connect legal concepts to real-world Arizona practices, showing how transactions are made safe, insurable, and recordable. Legal and equitable title. When people say they hold title, they usually mean they own the full bundle of rights that come with real estate, including the right to possess, use, enjoy, exclude, and convey. More precisely, legal title is the enforceable ownership recognized by law and confirmed by a deed. Equitable title is the recognized right to obtain legal title under a contract or security instrument. In a deed of trust state like Arizona, the borrower has equitable title, while a neutral trustee holds bare legal title with the power of sale for the lender's benefit. When the loan is paid off, the beneficiary instructs the trustee to record a deed of reconveyance, returning legal title to the borrower. Think of legal title as the completed handoff and equitable title as the ticket that guarantees the handoff once the contract is fulfilled. For example, in a contract for deed, the buyer moves in and pays over several years while the seller retains legal title. If the buyer completes the payments, legal title transfers. Likewise, a lender may hold equitable rights to obtain legal title upon borrower default. Understanding these distinctions helps real estate professionals analyze who holds what rights at any moment. How the law decides who owns notice of title. Real estate ownership can last for decades, so disputes sometimes arise over who truly owns a property. Our legal system resolves these questions through notice, determining who knew what and when. Actual notice is direct knowledge, such as reading the deed, attending a closing, or observing who occupies the property. Constructive notice is legal knowledge imputed to the public because documents are recorded in official records. For example, recording a deed of trust, or notice of trustee's sale provides constructive notice to the world. Even possession can serve as constructive notice since a buyer is expected to inspect the property and see who occupies it. Imagine a buyer who reviews the title commitment, visits the property, and observes a shared driveway. The records show a recorded easement, and the physical evidence matches. The buyer has both actual and constructive notice, the strongest combination to prove ownership and identify existing rights. Voluntary and involuntary transfers of title. The transfer of ownership from one party to another is called alienation. When an owner chooses to transfer title, it is voluntary alienation, usually through a deed during life or by will at death. A deed transfers ownership now. A will, which takes effect at death, directs how the decedent's property is distributed by device for real property or bequest for personal property. To be valid, a will must be written, signed, and properly witnessed, unless it is a valid holographic, handwritten will in Arizona. After death, probate proves the will, settles debts, and distributes property under court supervision. Voluntary transfers also include dedication, a private owner giving land to the public, such as for roads or parks, and gifts, transfers without consideration. In contrast, involuntary alienation occurs without the owner's consent, such as through foreclosure, eminent domain, adverse possession, escheat, or estoppel. Each process ensures that property remains legally owned, even when ownership changes hands by law or necessity. Why title insurance exists. Because human error and missing records can create uncertainty, title insurance protects owners and lenders against covered losses arising from past defects. Unlike other insurance that covers future events, title insurance is backward-looking. It protects against what might have already occurred. A title company examines public records, verifies the chain of title, and issues a commitment showing requirements and exceptions. After closing, the company issues the policy for a one-time premium. An owner's policy protects the buyer and their heirs up to the purchase price, while a lender's policy protects the mortgage holder up to the unpaid balance. Policies may cover forged deeds, errors in recording, or undisclosed heirs. Exclusions typically include zoning issues or known encumbrances listed in Schedule B. In Arizona, it is customary for sellers to pay for the owner's policy and buyers to pay for the lender's policy, although this can vary by contract or loan type. Recording and notice recording makes ownership and claims part of the public record, establishing priority and protecting against later claimants. A valid deed conveys title when delivered and accepted, but recording ensures constructive notice, so others cannot later claim ignorance. Documents such as deeds, mortgages, liens, easements, and releases should be recorded in the county recorder's office where the property is located. Arizona law does not require recording for validity, but it is essential to protect the grantee's interest. In everyday practice, clean recording is what turns private agreements into public facts, giving confidence to buyers, sellers, and lenders that ownership is secure and traceable. Deeds of conveyance. A deed of conveyance is the written document through which ownership passes from grantor to grantee. To be valid, it must be in writing, signed by a competent grantor, identify a legitimate grantee, include a legal description, express intent to convey, and usually be acknowledged before a notary. Delivery and acceptance are critical. The grantor must intend to transfer ownership, and the grantee must accept it, usually by taking possession or recording the deed. Once this happens, ownership is complete, even if the deed is lost later. Deeds contain several clauses. Granting clause expresses intent and identifies the parties. Habendum clause defines the estate, e.g., to have and to hold in fee simple. Redendum clause reserves conditions or easements. Covenant clauses include promises about title quality. Common covenants include warrant of seizin, grantor owns and can convey. Warrant against encumbrances, no undisclosed liens. Warrant of quiet enjoyment, ownership won't be disturbed. Warrant of further assurance, grantor will correct issues. Warranty forever, grantor will defend the title. Different deeds provide different protection. General warranty deed, highest protection, covers all title defects, past or present. Special warranty deed covers only defects during the grantor's ownership. Bargain and sale deed implies ownership but gives no warranties, often used in foreclosure. Quick claim deed transfers any interest with no warranties, used to clear clouds on title. Beneficiary deed transfers property automatically upon death without probate, Arizona specific. Disclaimer deed allows one spouse to disclaim marital interest in property held as sole and separate. Although Arizona does not impose a real estate transfer tax, each recorded deed must include an affidavit of value disclosing the sale price for property tax purposes. Wills and Probate A will direct how a person's property will be distributed after death. The person making the will is the testator, and those receiving property are devises or heirs. Wills can be witnessed, holographic, handwritten, or created using approved forms. Arizona does not recognize oral, non-cupative wills. The probate process validates the will, pays debts and taxes, and transfers remaining property. If the person dies testate with a will, probate follows the testator's wishes. If they die intestate without a will, property is distributed under Arizona's laws of descent. Probate occurs in the jurisdiction where the property is located and ensures that ownership is transferred lawfully and debts are satisfied. Involuntary title. Transfer. Sometimes ownership changes hands by force of law. These transfers occur without consent, such as foreclosure, when property is sold to satisfy a lien. Eminent domain, where government takes property for public use with compensation. Adverse possession, when someone occupies land openly and continuously for a statutory period, 10 years in Arizona. Escheat, when the owner dies without heirs and property reverts to the state. Estoppel, when a party is legally prevented from denying previous actions or claims. Natural causes, such as erosion, avulsion, or accretion, which physically alter property boundaries. Each of these ensures that property remains legally titled and traceable in the public record. Title recording and chain of title recording ensures transparency and public evidence of ownership. County recorders maintain archives of deeds, liens, and easements, forming a property's chain of title, the chronological history of ownership. If any link is missing or defective, title is considered clouded and must be corrected through a quiet title action or corrective deed. A title search examines these records, while an abstract of title summarizes them. Title companies maintain title plants to streamline this research. Some states use the Torrens system, where title exists only when registered, but Arizona does not. Instead, Arizona relies on traditional recording to establish constructive notice and legal recognition of ownership. Review summary. Title defines ownership rights in real estate and moves through voluntary or involuntary transfers. Legal title represents actual ownership, while equitable title gives the right to acquire ownership. Notice, both actual and constructive, determines who has valid claim to property. Title insurance protects against past defects, and deeds serve as the vehicle for transfer. Recording secures public notice and establishes priority, ensuring that buyers, lenders, and future owners can rely on the record. Understanding these concepts is essential to protecting ownership, avoiding disputes, and ensuring marketable title in Arizona transactions. Discussion. Why does equitable title matter to a buyer who hasn't received a deed yet? It grants enforceable rights to obtain legal title upon completing the contract and often supports possession and improvements under the agreement. How do actual and constructive notice work together to protect a buyer? Actual notice comes from direct knowledge, while constructive notice arises from public records and visible possession. Together, they prevent fraud and protect diligent buyers. Why might a quitclaim deed be used? To clear clouds on title or remove a spouse's name after divorce without warranties of ownership. How can adverse possession be prevented? By inspecting the property regularly, removing trespassers, and filing a quiet title action if necessary.